Hello, my name is Debbie Reynolds. They call me the Data Diva. Today I want to talk about data privacy and HIPAA adjacent data. So I call any data in the US around anyone's health that's not regulated by the HIPAA privacy rule, HIPAA adjacent. So that means any organization that's dealing with data in spaces where they're not either a patient or a provider, or they're somehow related in the chain of some type of official medical procedure or situation. So, these spaces, for example, we're seeing companies come out with things like emotional AI, things around people's health or mental wellness in AI where there isn't maybe a doctor or a clinician involved. This is an issue because a lot of this data in those spaces in the US especially is not regulated in the same way. So they have lesser protection than people may imagine or may think of. Companies that are developing products in this space may not know what they need to do in these areas when they're dealing with stuff. But I thought it was really interesting, pretty interesting development that happened recently is that the state of Illinois passed a new law. It's called the Wellness and Oversight for Psychological Resources Act, WOPR. And so this act, it went into effect in August of 2025. It was unanimously agreed upon in both houses in the state of Illinois, and the governor signed it into law to go into effect immediately. So what this law does is say that uh, no one who is not basically the law says that if you're not a licensed professional, you cannot use or advertise the use of AI for any type of medical things. So that means that if, for example, someone is like advertising a chatbot saying that they can help someone with their health or wellness or mental state, they cannot do that unless they're actually a licensed professional in the state of Illinois. So some of the things that are permitted for people. So let's say, for instance, there is a clinician that's licensed in the state of Illinois. They're also limited in what they use AI for. So they can use it for things like administrative support, like scheduling meetings, possibly doing appointments, helping with billing. They can use it for supplementary support, like drafting session notes, anonymized data analysis, but some of the things that they cannot use it for is that they can't have AI chatbots independently making therapeutic decisions. They're prohibited from making treatment plans without a clinician involved and having oversight. And then the patient cannot talk directly to a chatbot without a person being involved. And then also, the part I found very interesting, they don't want people using chatbots to try to detect someone's emotions or their mental state. So this has pretty broad implications. We've not yet seen any other state step up and really articulate their idea of how people need to be using AI in, a medical or medical adjacent settings. But I think one of the best parts of this law is making sure that if people are using AI, they are using it in a patient provider setting so that it is covered by HIPAA in the way that they're using it. And they're trying to make sure that it's prohibited for people who are outside of those guardrails, that they're not using AI in those ways. So we've already seen, obviously, with the EU and the AI Act, some of these things are covered. Actually, some of the things we've talked about, including emotional AI, is prohibited under that act. But I think we're going to start to see a lot more movement in the US for states to try to regulate more AI as it relates to maybe these more sensitive areas around health, because I think a lot of people don't typically know that these things have lesser regulations. And also for companies that are building tools that they're using this type of data, they need to really think about what those implications are regardless of where they do business. That's it. Thank you.